Welcome once again, and really for our last recorded lecture for the semester here in the fall of 2019. Welcome for the full semester and second 8 weeks classes. Our last recording, chapter 15, the last of the 15 chapters that we'll have for our final that we'll have in December during finals week. Please check your syllabus and also our main page for the listing of the times for our test. We'll have the test on 2 separate days that you can pick from to take that final. It'll be 2 hours in length once you log on, and you'll have 100 questions that you'll be taking online, multiple choice questions. So you can also use ProctorU if you'd like to take that exam at home. So this will be one of the 15 chapters that we'll have covered for that. Some of this, certainly some of the questions may come from our recorded lecture. And of course this is also used for our chapter quiz, and in part used for our last of our midterm tests that we have on that first week in December. So here we are with Chapter 15, the Supreme Court. Again, from the beginning part of the text, you have a lengthy passage here that I direct your attention to on page 592. The heavy use that Americans make of the courts is also an indication of the extent of conflict in American society. And given the existence of social conflict, it is far better that Americans seek to settle their differences through the courts than resort to violence or otherwise take matters into their own hands. I think this is a very important point. And so while there's criticism of the United States that we are known to be a very litigious society, that when people have problems, they go to court to settle those problems. What other way would be best to settle these problems? So that's the argument made by your authors, that perhaps this is used too much, but what is the better resolution? And so indeed, the courts are the process in which people use to try to settle differences. That can be viewed as a good thing. So read about that on page 592 in your text, and helps to set the tone about the courts in the United States, in particular the top federal court, the Supreme Court. The Supreme Court makes some major changes in our society. Now, in some ways, are they reflecting other movements in society, or are they actually sitting the process? That's a question for a different class and a different time, but we can certainly see the outcome of their decisions. For example, in some ways, it might seem to be not that important at the time, but can have an impact. So this is in California in 2011, as you can see there, Brown versus Entertainment Merchants Association. And the state of California, the legislature of California, wanted to require that, or actually ban the sale of violent video games to those under the age of 18. And the Supreme Court ruled that that was a violation of the First Amendment. It was up to families to make that decision on the purchase of violent video games. Kind of interesting in that case, but it then shows us that the power of interpreting the Constitution, the organization that has the most power in that interpretation, is the Supreme Court. So you and I can have an interpretation of the First Amendment and what applies, but it is consistently the respect and the following of the Supreme Court that means that their interpretation is what matters most. So their interpretation of the First Amendment would be, this is in violation of that amendment to limit the purchase of violent video games. So an interesting case there, Brown versus Entertainment Merchants Association. We've seen throughout this class examples of the court's power. And so I'll just direct your attention to some of the cases that we've covered, primarily going back to chapters 4 and 5. But you recall that in chapter 5, we talked about Brown versus Board of Education, ending legal segregation, de jure segregation in the classrooms. Gideon v. Wainwright, chapter 4, the right to an attorney, and the Sixth Amendment. Lawrence v. Texas, both chapters 4 and 5, the right for same-sex relationships, and that the state cannot limit or make laws against those same-sex activities if they're allowing for those same activities among heterosexual couples. McDonald v. Chicago, the Second Amendment, that the right to purchase a handgun follows the Second Amendment. And we've talked about Brown versus Entertainment Merchants Association. United States v. Jones, interesting case, which is brought out in this chapter 15 on the limits of how long a GPS device could be placed on a car according to the Fourth Amendment and a search. What is a reasonable search? There is a limit to how long that GPS device can stay on a car and stay within the boundaries of the Fourth Amendment. Who makes that interpretation? The Supreme Court. We've seen in the year 2015, for example, some very important cases that were decided, such as the Affordable Care Act was upheld, Obergefell versus Hodge, versus Hodge, ruled that the 14th Amendment recognized the national right to same-sex marriages. So here we're seeing what ruled the constitutionality of a same-sex marriage according to the 14th Amendment, equal protection under the law. And then we've seen some recent years here, Fisher University of Texas, that still considered race as part of the admission criteria into a university. And we can see here Gamble v. U.S. 2019, just throwing out some examples of the power of the courts here. Some areas have been pretty well known. Again, the same-sex marriage ruling. And then here we can look at a case involving double jeopardy, that it's not a violation of double jeopardy to have state and federal courts can continue to prosecute defendants for the same crime. It's not a violation of double jeopardy. So all these are just giving you some examples of the power of the courts. These are the current individuals who make up the Supreme Court. And there's a chart in your text that shows you that. Notice here that the Chief Justice does not have to be the senior member of the court, and that there are, as we can see here, some other officials that are that have seniority over the Chief Justice. Here we can see the power of the Chief Justice, and some of the main areas where we can see the power of the Chief Justice deals with assigning opinions of the court and who has authority in this case. If the Chief Justice is not part of the majority in assigning an author of the opinion of the court, then it will be the senior justice that has that authority. So the senior justice that is within the majority. So always want to clarify that. If you had a 5-4 decision and the senior justice was part of that 5 and the Chief Justice was part of the 4, then it's going to be that senior justice with the most seniority that would be able to determine who would write the opinion. Well, that's writing the majority opinion. There are justices that can write dissenting opinions. Any justice that's on the court can write a dissenting opinion. I have a picture here of Thurgood Marshall, first African American on the Supreme Court, who would always write dissenting opinions about the death penalty. So there was always a majority that was supportive of the death penalty, finding it to be constitutional, he would still write a dissenting opinion. And of course, he would write those dissenting opinions not so much for the people who were on the court at that time, for the fellow justices on the court. He would write the dissenting opinion for future courts and for future debates and research about the death penalty, with the hope that that would eventually cause people to not support the death penalty. So some of the reasons for writing a dissenting opinion. And there's also, you have a majority opinion and the power of the Supreme Court Chief Justice in determining who would write the majority opinion. Then you have dissenting opinion, and here you can see you have also plurality opinion. And in the plurality opinion, there is no majority. And so you can reach a conclusion here that plurality opinions just really don't seem to go too far in having an impact on a particular question about constitutionality. But that can just tell us this is where the courts would be on some particular issue, that you don't have a strong majority. So those are the different opinions that the courts can end up writing. Majority opinion, dissenting opinion among particular justices, and then also here a plurality opinion. Now, when cases get to the Supreme Court, there are two pathways here. One is original jurisdiction, and the other one will be appellate jurisdiction. Roughly about 100 cases a year that the courts will decide to hear, out of about 4,000 that are appealed. Of those, you have roughly 1 or 2 cases a year that would fit within the parameters of original jurisdiction. And so these would be cases that will go directly to the Supreme Court. So here you have the examples of a case that might fit within original jurisdiction. And so many of these cases are just never going to, are just not going to have too many examples that would fit within original jurisdiction. I do not believe there's ever been a case, for example, like number 3. So this is really where you have diplomatic immunity, and so most foreign ambassadors would not be tried. And they're certainly not going to be tried by the Supreme Court, even though that is part of the Constitution and the basis of a case involving original jurisdiction. So again, this is roughly 1 or 2 cases a year might fit within some of this area of original jurisdiction, especially the areas of 1 and 2 that we see listed here. So the remaining cases would be under appellate jurisdiction, and this is where most of the cases clearly fall under. Someone has lost a case and they're appealing to a higher court to review the proceedings, asking them to review what happened in this case. Was it constitutional? That's the power of the Supreme Court, or certainly other higher courts, but in particular, as we're covering here, the Supreme Court. Was the case within the guidelines and the proper interpretations of the Constitution? That's what happens during an appellate jurisdiction. So as you can imagine, if there's roughly 4,000 cases a year that are decided by the court and only about 100 that are heard, most cases are never going to be reviewed by the court. So what is it about those 100 cases a year that would be decided? Well, they would fall within these primary reasons that the court hears a case. And it's a constitutional issue that has to be resolved. We've talked about particular cases that we'll come back to that would fit within these reasons. So Griswold v. Connecticut is a reason that it had to at that time be resolved. There's a particular ripeness to a case. So just like when is the right time to pick an apple off the tree, for example, it's ripe at that time. You have a conflict with 2 lower courts. They've decided a similar case differently, as you can see there for number 3. It's an important national issue. Perhaps it's involving the president, so it needs to be resolved quickly. These are reasons for the Supreme Court to hear a case. So ripeness, for example, campaign finance, going back to the Citizens United case. And here we're looking at gun control, McDonald v. Chicago. Is it within the parameters, the correct interpretation of the Second Amendment to allow people the right to have a handgun? And that was the debate within the case McDonald v. Chicago. So a very ripe case that needed to be decided. You have conflict with two lower courts deciding similar cases differently. Should the courts do the courts rule that police need a search warrant to review someone's cell phone? One lower court ruled yes, another lower court ruled no. And so in the Supreme Court case Riley v. California, the court ruled yes, that the police must have a search warrant to search one's cell phone. That's how to resolve the different lower courts' decisions. And we have seen cases involving presidents, so releasing the tapes or allowing those tapes to be protected under executive privilege. The court ruled that the tapes needed to be released in 1974 involving President Nixon. With President Clinton, can a president be sued while in office? And the courts ruled yes, a president can be sued in 1998. So both of those are compelling national issues involving presidents and needed to be resolved. When the case is decided by an appeal, there's a particular process involved. Part of that involves some legal terms that are used in Latin. Latin is being used because these are this is a language that's not put into daily use, and so therefore the terms that are used in Latin should tend to be the same for many years, since there's not a daily use of language of the language Latin, which has a tendency to cause languages to be to evolve and to take different words to take different meanings. That should not be the situation here for Latin. So in that process, lower court loser writes an appeal to the Supreme Court. Maybe that individual who has lost, who's in prison and has really no means of being able to come up with a fair defense and a good appeal outside of that individual's own finances, and so the individual appeals on his or her own without any legal assistance, and that person has that right to do so. As we can see there, it's referred to as a writ of pauperis. Once that appeal's been made, you have clerks that are reviewing the cases, and they will then make recommendations to the justices to hear a particular case. And so at least 4 justices must agree to hear a case. So that's called the rule of 4. Once 4 have decided, then the court issues a writ of certiorari, and that's commanding an inferior court to turn the records of a court case over for review, so that the Supreme Court will now review that particular case. The power of the courts, and the reason why we're talking about the Supreme Court as one of these branches of government that can limit the power of the other 2 branches, is from judicial review, is the basis of judicial review, their ability to interpret and judge the constitutionality of a case, the constitutionality of a law, and that comes from this court case, Marbury v. Madison. So certainly read about that on page 604 in your text. Brief description of the case here. There's a lot to be said about it, but Marbury was expected to be appointed a officer of the court that he was going to be getting this promotion, and he was appointed at the time when John Adams was the president, and so he was a supporter of John Adams. And once Adams left the office, the appointment was not carried out by Jefferson. So Marbury sued and believed that he had a right to sue, and he wanted to get the Supreme Court to follow through with his lawsuit. And this is actually referred to, the term here is called writ of mandamus. And a writ of mandamus is a requirement, a court order, a request to get an official to perform a duty if they believe that this official's not doing a particular job. So that was what Marbury was hoping for. Marbury in these two pictures you can see on the left. Well, and Madison was Secretary of State. He was holding on to the papers, and so he was holding on to this appointment, but it was made by Adams, and this paperwork had just not been completed. So when Jefferson takes over, he just says, I'm not going to carry out this particular appointment. And that's where the writ of mandamus comes in. So Marbury is asking the Supreme Court to do this. Well, the Supreme Court is now a bit in a struggle here because Jefferson just says he's not going to obey what the courts say anyway. They don't have a right to make him do this, make him honor an appointment by a previous president. So what's the courts to decide? And the basis of this then is that the courts rule that according to the Constitution, their interpretation of the Constitution, they do not have the power to issue the writ of mandamus. So it appears like that the Supreme Court has admitted its weakness. But what it has also said is that it will be the Supreme Court to decide whether or not a law is constitutional. And so that becomes a very important basis then of the power of the courts, the ultimate power of the courts, the power of judgment. So they're making a decision on the constitutionality of laws, which is based on the tradition from this case, Marbury v. Madison. One of the traditions of the courts, by and large, has been to stand by that which has been decided. That's a Latin term, stare decisis. So in that sense, inherently, the court's pretty conservative. A reluctance to overturn past court decisions doesn't mean that they don't do that, but there's some reluctance there because if they overturn a past court decision, what does that say about their own court decisions? So there has been that tendency to not overturn past court decisions. You may then see or hear about individual justices that look at a particular case and say, that's not how I would have decided it. But since it has been decided, I'm not going to overturn it because I am reluctant, a justice may be reluctant, to weaken the traditions and the standing of former court decisions. So the tendency then to continue on with particular court decisions. And here we can see that the justices then have that decision on how much of a power should the justices have to make a law. Maybe in some cases they need to make a law and have that ability, but are they the lawmaking branch? So judicial activists are the claim that some justices are judicial activists means that they're more likely to interject themselves in the making of a law, whereas those who are following judicial restraint are not wanting to do that. Their own job is just to interpret the law, not to actually make that. But that becomes, of course, a rather fine line and not that easy to always make that determination. And maybe there are times in which, if no one else is stepping up to really make a particular law, then that becomes the role there of the justices, and makes them also judicial activists. All right, you can read about that, as you can see there on pages 616, and there we can see part of the ongoing debate of the role of the judges. And that's where we are here with this particular recording on chapter 15. And again, we've covered the Supreme Court and many other areas in our class throughout this semester. So we'll stop there with this area on the Supreme Court, and hopefully you'll be able to spend the rest of this semester getting prepared for that final and our last test. And perhaps if you're watching this fairly early, you'll also then be reminded that we have our research paper coming up here on the 18th of November. Hope that you've enjoyed this semester and these last few weeks, that you'll have some productive times getting ready for some of the key events that we still have here for this semester.